Hello and welcome. We are Sukarm and Nidhi, editors at Law School Policy Review, with our observer Smriti. This is a podcast as a part of our series Arbitrary. We are excited to introduce our guest for today, Ms. Kanika Jamwal. She is a research assistant. She's a research fellow at NUS and an assistant editor at Indian Law Review. She is known for her distinguished contributions in the field of climate change and policy. So we're very excited to have her here.
Right. Thank you so much, Sukram, Nidhi, and Smriti. Thank you for that introduction as well. And I'm glad to be here. So thank you so much.
Thank you so much, Kanika. The theme for today's discussion that we have kept is Vanuatu's draft resolution for ICJ's advisory opinion. So, Kanika, why don't you go ahead and introduce the campaign for us first?
Sure. So, okay, so the advisory opinion that Vanuatu is seeking from the International Court of Justice is actually a very interesting, but rather regular procedure that it's within the advisory jurisdiction of the ICJ. So it's not something extraordinary, but of course the theme for the advisory opinion is very important and is crucial. This journey goes back to 2019 when there was a coalition of students from the University of South Pacific who decided to bring the question of climate justice before the International Court of Justice. Now that group of students is called the Pacific Island Students Fighting for Climate Change, and it's become a bigger movement. And the core purpose of the movement was to, and continues to be, to convince governments to support them in seeking an advisory opinion from the ICJ, governments across the world, different countries. So cut to 2021 September, when Vanuatu, the Republic of Vanuatu and the government decided to launch a campaign seeking an advisory opinion from the International Court of Justice. Recently, on November 30th, Vanuatu finally published a draft of the resolution that they have now tabled in the United Nations General Assembly. And this resolution, if passed, will go to the ICJ seeking their advisory opinion on the question of obligations to prevent climate harm. And the second question is liability for climate harm. Right? So these are the two key points that the resolution sort of, at least the draft, seeks to ask the ICJ or raises before the ICJ.
Thank you, Kanika, for setting the context so well. So, moving specifically, what legal implications does an advisory opinion have? So, even listening to it, advisory sounds non-binding. So, what implications would an advisory opinion have in case of future litigation?
Okay, so see, when you look at an advisory opinion, now why I was talking about the ICJ and its advisory jurisdiction is because going back to the ICJ statute, you see that the ICJ has two kinds of jurisdictions, right? One is its contentious jurisdiction and one is the advisory jurisdiction. Now, ordinarily, under the contentious jurisdiction, it is only the states that can raise a dispute before the ICJ. Okay? And the states can say that, hey, we have a dispute, and then the ICJ would pronounce a judgment on that dispute. Now, this judgment is then binding on the states that have referred the dispute to the ICJ. That is both or n number of state parties who are involved in the dispute, right? We've had several such cases before the ICJ. The second is the advisory jurisdiction of the court. Now, the advisory jurisdiction of the court is particularly for international organizations who otherwise can't go under contentious jurisdiction, right? They can only go under advisory jurisdiction and move the court to give and request the court to give an advisory opinion or an opinion on a legal question, right? Now, you're very right, Sukram, and this advisory opinion is non-binding in nature. While a decision that's given under the contentious jurisdiction is binding in nature, an advisory opinion will always be non-binding in nature. Okay. There have been a few instances in the past where there have been advisory opinions that are binding in nature, but those are exceptions. Generally, advisory opinions are non-binding in nature, and it's usually left up to the organization in question to then decide what to do with the advisory opinion. Right? That being said, an advisory opinion has a significant amount of legal as well as moral value, right? Moral authority and legal significance. Why is that? And how is that, right? An advisory opinion firstly clears the stand of international law, the position of international law on a given issue. Now, we know that usually issues that appear in the global context can be very politicized in nature, right? So, what an advisory opinion does is that the court takes the law and tells you that this is the position of law on this issue. So, in the past, too, the court has given opinions that have protected the rights of states and vulnerable people, right? And the court has said that all of this is fine, but this is what the law says. Okay. And how can this be used? This has interpretative value. It can be used in legal arguments. The advisory opinions of the courts have been used in legal arguments in cases before the court itself. And a lot of times they may also be used in domestic cases wherein, say there's a issue, say there's a climate litigation case, and as a part of international law, then advisory opinions may be drawn upon, right, to understand international obligations or obligations under climate change instruments as Vanuatu's opinion. That's what Vanuatu's opinion seeks to know, right? So while it is a very ordinary procedure and it is not something out of the box, the theme for this advisory opinion is definitely very, very crucial. But why I'm saying that this is an ordinary procedure and it's not something out of the box is because states should not push back too much against seeking this advisory opinion, right? Because this is something that the court is very much empowered to do and that the GA is very much empowered to seek from the court. So ideally, states should not push back too much. This is not an extraordinary power that the court is going to be using. But yes, certainly the issue that Vanuatu and the coalition of states seeks to put forth is a very important issue. And ICJ is perhaps the only international body that's still not addressed the issue as such directly as a main question, right? So this holds significant value for future climate litigation.
Thank you, Kanika. But just following up on that, you had mentioned that on the 30th of November this year, specifically, the draft resolution was released by Vanuatu. Could you also explain the draft resolution and what does the draft resolution exactly consist of?
Okay, yes. So the draft resolution is, again, I personally find the document very compelling and also groundbreaking in a few aspects, and I'll just touch on those. But to begin with, see, when you look at Vanuatu, then it's the website is just beautiful. When you go and look at the website for the ICJ initiative, you see they've given the draft resolution and then they've explained the draft resolution to you. They've said that here's some understanding how to approach the draft resolution. So very nicely, they break the draft resolution into two parts. Okay, the first part is the preambular section of the draft resolution, and the second part is what they call the operative part. Now, the preambular part, it of course has a few acknowledgements and a few things that Vanuatu and coalition of states, and if it's passed, then the entire General Assembly acknowledge and give importance to. And two of these things are something that I would want to point out. One of it is the fact that the draft resolution, like the preambular part of the Paris Agreement, also acknowledges that while impacts of climate change are a universal phenomena, they're not a uniform one, right? So they say that small island states and certain developing countries are particularly vulnerable to the impacts of climate change. Now, that acknowledgement is very important because that acknowledgement also directly relates to the issue of climate injustice, right? Those who are contributing the least to climate change are the ones who are suffering its impacts the most. Okay. So this is para 7 of the preamble, which talks about the disproportionate impact of climate change on small island states and other developing countries that are vulnerable. And so, therefore, while vulnerability is a uniform phenomena, it's a universal phenomena, it's definitely not a uniform one. Some states are going to be more vulnerable than others, right? Within a country also, then some people will be more vulnerable than others. So on a micro level, you see vulnerability playing out in this way, wherein certain sections of the population may be more vulnerable than others. And on a macro level, you see it in the context of states, wherein some states altogether are more vulnerable than the others. The other thing, and this has been an acknowledgement that's existed for a while, is that there is an increasing scientific consensus now on the fact that greenhouse gas emissions have led to the temperature rise that we've been noticing since the 1950s. Okay. Why is this important? What is the value of this acknowledgement particularly? See, one of the problems that comes up in climate litigation is often causation, right? How do you link the impact that a particular country is facing to the emissions that another country has done? It's very difficult because the nature of climate harm is such that it's non-linear. It's not that A country's emissions have caused this impact in B. There can be several other, causes that could have caused those impacts. So this causation link is difficult to always make. But now with scientific advancement, there's been an increasing consensus that greenhouse gas emissions that have happened historically are responsible for the temperature rise that we've been seeing since the 1950s. Now, this historical emission is key here, right? And I'm just going to refer to it in a bit. But now coming to the operative part of the resolution, there are again two parts of the operative part as well itself. One paragraph of the operative part, which is the opening paragraph of the operative part, spells out the law or the international legal framework for climate change. Okay, so it talks about, it says that we seek ICJ's advisory opinion on the basis of essentially the following, under the following legal framework, and these are the two questions. Now, what are those laws? So it lists down conventions. It talks about the Covenant on the Covenant CPR. It talks about the Declaration on Human Rights. It talks about the UN framework on climate change. It talks about the Paris Agreement, and interestingly, it talks about general principles of international law. Right now, what is interesting here is that it does not refer to customary international law. Okay. Now, and this is just me honestly thinking out aloud as to what could be the reasons why is customary international law not brought within that list. One of the things could be that when you look at the principles of customary international law that exist in the context of international environmental law and climate change law, most of these are a part of your conventions like the UNFCCC or the Paris Agreement, right? If not, they will be in your human rights conventions, right? And the second thing perhaps could be that some of these principles that supposedly have a customary status have themselves been challenged in the sense that their customary status is not that well settled, right? So, for example, one could argue that the precautionary principle is a principle of customary international law. There have been decisions of the Indian Supreme Court as well that have said that. But in all I mean, overall, if you look at how international law approaches the precautionary principle, it's deeply contested. The very nature of the principle is contested. Which version are we ascribing to? How do you sort of balance it with proportionality? All of these are contested issues within this principle itself. So that could perhaps be another reason to not go down that road and just refer to the UNFCCC and the Paris Agreement, right? And in all honesty, I mean, reference to both of these is, in my opinion, enough, because when you look at the Paris Agreement at this point, all countries have signed the agreement. It's just 3 or 4 countries that have still not ratified, but it has signatures from all countries, right? And so there's, at least in that sense, it's a very comprehensive, overreaching agreement, and that all countries have now agreed to sort of submit their NDCs and undertake climate action, so on and so forth. So whatever obligations or liability are spelled out in furtherance of the Paris Agreement, say, for example, by the court, would anyway be then, can be used by all countries, because all states are a party to the agreement. So anyway, in terms of membership, it covers pretty much all states across the board. So customary international law, or even for that matter, general principles of international law that could say help us bring into their ambit states that are at the flanks or that are beyond these conventions, may not even be required, given how globally how well accepted the Paris Agreement is. The second operative part of the draft resolution is the main question that the coalition seeks to ask the ICJ, and there are two questions. One of them is, the first one relates to obligations, and the second one relates to liability. Okay. So when you look at the first question, it says that what are the obligations of states under the laws that have been presented in the preceding paragraph to ensure protection of the environment and of the climate system for the present generations and the future generations. Now, there are two important things here. One is that it talks about obligations of all states, right? Doesn't distinguish between developed states, small island states, so on and so forth. It says what are the obligations of state under these conventions, under this legal framework, for protection of climate system as well as parts of the environment, and for the present generation and future generation. So there's a concept of intra as well as intergenerational equity. These two principles find themselves in this first question. Now, the second question is where I feel that the resolution actually breaks new ground. The second question says that what are the legal consequences for states who, due to action or inaction, have caused harm to climate systems or to parts of the environment, with respect to, and then it says, particularly with respect to small island states and other developing countries that are vulnerable to these impacts, disproportionately vulnerable. And the second part, present generations and future generations. Now, what is interesting here is that, one, there is an interstate element also. So it's saying responsibility of states that have caused this harm due to their action or inaction. Legal consequences for states that have caused this harm due to action or inaction, particularly with respect to small island states. So what are the legal consequences with respect to the harm that has been caused in small island states and other developing countries that are particularly vulnerable? And of course, then there is, people of the present generation and future generation. So unlike the previous question, where we're talking about obligations of all states, here, when we're talking about legal consequences, or like I would understand it as liability for harm, we're only talking about harm that has been caused by certain states, and what is the responsibility for that harm, particularly in the context of the harm that's manifesting itself in these two sort of, within certain states, or say, for example, within this generation or future generation. So yeah, that is how I think summarize the key elements of the resolution. Now, of course, a lot of the comments that I've brought in are my own, and they're not actually as such in the agreement, in the resolution. So yeah, just flagging that up.
Thanks, Kanika. Just to follow up on some of the things that you said. So specifically litigation, how would you trace it within the agreements or the framework that there is? Like specifically, could you take us through the Paris Agreement or the UNFCCC and discuss what legal obligations there are on member states to respect the SIDS and other effects of climate change?
Okay, so that's a very good question. So when you look at obligations, and which is sort of the first question, right, of the resolution as well. When you look at obligations, you need to go back to 1992 when we signed the UNFCCC, right? Now, before we understand obligations, we need to understand how have obligations changed over time. And by change, I mean not the nature of obligations, but who holds these obligations. Starting from the UNFCCC, see, from 1992 UNFCCC to 2015 Paris Agreement, obligations have been based in the principle of common but differentiated responsibilities, right? This principle has changed, right? And states that have obligations have also changed. Now, the principle of common but differentiated responsibility is simple. It says that everyone has a common responsibility to address climate change. Why is that? Because climate change is a phenomena that doesn't respect boundaries. So it's not that the impacts that X country is suffering is because of the emissions of X country. No, it can be because of the emissions of A country. So everyone has a common responsibility to address climate change, to mitigate and adapt to climate change, take climate action. How are these responsibilities differentiated? Now, in 1992, what they did was they said, yes, everyone has a common responsibility, but this responsibility is differentiated because of the disproportionate historical contributions to greenhouse gas emissions. Now, back in 1990s, the idea was that the so-called industrialized or developed countries had been emitting, greenhouse gases for over like a century. And because of that, the impacts of that was global warming that we were observing since the 1950s. Because see, climate harm, the nature of climate harm is such that if emitters of today, the impact of it, we'll not see it tomorrow. We're going to see it 50 years down the line, right? So they said that the countries that have emitted so far and have taken the benefit of those disproportionate emissions in terms of development and economic growth should be the ones who should take mandatory obligations with regards to mitigation as well as adaptation. Now, this was largely your industrialized / developed countries of the time. And they said that on the basis of this historical responsibility, then, countries that have historically not emitted but are now emitting should only have voluntary mitigation and adaptation obligations and not any mandatory targets, right? This was based in the principle of equity. Simple logic. Those who've emitted in the past cut down now, and the emitters of then will cut down in the future. So that way it becomes an equitable distribution. This is why historical responsibility was the cornerstone of the principle of common but differentiated responsibility, because that was used as the differentiating factor. And of course, in addition to finance, financial conditions of countries, right? So respective capabilities based on your financial conditions as well. So this is where the differentiation came in. But historical responsibility was what was introduced and solidified by the UNFCCC. What this did was that this divided the negotiations into two camps. One camp led by the developed countries, which said that we will not take mandatory targets unless developing countries also undertake certain targets for mitigation and adaptation, which may be different in length and breadth. But it's not that we'll have mandatory targets and they'll only have voluntary targets. Developing countries, on the other hand, stood firm on their stance that, see, differentiation is the principle of differentiation is going to play out on the basis of historical responsibility for emissions, and we will undertake only voluntary targets. Both camps said that we adhere to the principle, but they had very different interpretations of this. So then came the Kyoto Protocol. What the Kyoto Protocol did was that it laid down quantifiable mitigation targets for developed countries and voluntary targets for developing and underdeveloped countries. This pushed climate action into a state of inaction for over a decade, because the United States of America, which was the largest carbon emitter, never came on board the Kyoto Protocol, and they passed a resolution in their Senate saying that the US will not undertake any more mitigation targets until developing countries also undertake similar targets, can be different in length and breadth. After 2010, skip to the Paris Agreement, they realized that this top-down mechanism is not working. And so now under the Paris Agreement, all states, regardless of your historical emissions, all states have adaptation obligations, mitigation obligations, as well as obligations for loss and damage, for addressing loss and damage, preventing loss and damage, I'm sorry, right? So arguably then, with the Paris Agreement, the idea of historical responsibility has sort of obliterated, right? It still says that this is based on the principle of common but differentiated responsibilities. But how is it differentiated? It's differentiated in the light of national circumstances, meaning that every country has a common responsibility, but the targets that they set for themselves will be on the basis of their prevailing national circumstances, and therefore there's this method of self-differentiation, because every country's national circumstances are going to be different. Every country is going to set its own targets accordingly. So now this has become a bottom-up process of submitting nationally determined contributions, which are based on your own national circumstances, and therefore it's largely bottom-up and self-differentiating. Okay. And so Paris has made the entire obligations system very non-adversarial in nature. What I mean by that is it's largely bottom-up and state-driven. There is no authority to kind of push you or to enforce those obligations, right? Now, for example, the Paris Agreement says that every subsequent NDC should reflect a certain amount of progress from the previous set of NDCs that the state party has submitted. But what is this progress is also something that the states will define on their own. State in question has to define progress on its own. So today, for example, country A says that, okay, these were my NDCs back in 2016, but then COVID hit us. And now these are my NDCs, which may be less ambitious than the ones in 2016, but it's still progress because of their national circumstances. They may well argue that our national circumstances only allow this level of commitment, right? So Paris is a very non-adversarial instrument, which is perhaps one of the reasons why you have such overwhelming consensus on the agreement. You have pretty much all states on board the agreement. And in that sense, Paris has been a big win. It was able to bring in all states on a single agreement after probably a decade of absolutely no climate action. So this is how obligations have sort of played out, right? Now, when you talk about enforcement of obligation, in terms of interstate enforcement, to the best of my knowledge, there hasn't been a case where a state has sued another state to enforce obligations under any of these instruments, right? What is perhaps, and what has actually happened, is citizens suing their own states, which is your wave of climate litigation, to enforce these obligations. Now, this is also not direct enforcement, because in most cases, you'll see that, say, for example, the agenda case, right? The Dutch government was sued on the basis of a duty of care under the Dutch Civil Code. And there was a reference made to the UNFCCC at the time. So it's not directly that the citizens have said that no, under the UNFCCC, the state has to take such action, so on and so forth. Because the agreement, these international agreements are between states. So citizens can't go on and say that, hey, you owe me obligation under this. No, states owe each other obligations. But still, the courts have drawn upon these in addition to, say, some national laws. And climate litigation, as you may know, has been increasingly successful. Our agenda was successful. The other set has been then against corporates, wherein citizens have gone behind corporates and asked them to undertake to cut their carbon emissions on the basis of, say, the UN principles, guiding principles on business and human rights. Or say a fine example is the Royal Dutch Shell case, wherein they were able to sue RDC on the basis of, again, tort law as well as human rights obligations. Now, interestingly, while the court did not directly apply human rights against RDC, because, see, RDC is a private corporation, human rights only exist against states. You can only claim them against states. But the court did use human rights to then interpret the duty under tort law, right? So that way, obligations are being enforced. But not, I haven't heard of an interstate dispute as such, where a climate obligation is directly enforced by one state to the other. But on that note now, when Vanuatu is asking the court, can you tell us states' obligations? I am assuming that in the future, this could be instrumental in climate litigation against states as well, perhaps launched by states. Of course, you can't use the opinion as a ground to do so, but certainly it will go a long way in aiding climate litigation cases.
Right, Kanika. Thank you so much for explaining the obligation part. But one question that I still have is, even if Paris Agreement is very non-adversarial, what mechanisms does it have to, enforce the liability? That is, how would the states claim the other state is liable, and how would the liability be calculated? Would there be compensation, and what could be the enforcement for this?
Okay, thank you for the question, Sukarm. So, see, interestingly, the Paris Agreement actually doesn't talk about liability, right? Which is why I was saying that the draft resolution is, it breaks new ground because it tries to bring in the question of liability before the court. Now, when you look at the Paris Agreement, right, and when you look at Article 8 of the Paris Agreement, it talks about losses and damage, right? Loss and damage, sorry. And it says that state parties shall take steps to prevent losses and damages. Now, losses and damages, put simply, are the impacts of climate change that have caused some harm. Okay, mitigation you'll undertake when the impacts have still not manifested. Adaptation you'll undertake when the impacts are happening and you're adapting to it. But loss and damage, or losses and damages, happen when the impacts have led to a climate harm and the harm has been caused. So the Paris Agreement says that states, under Article 8, it says that states shall undertake measures to prevent losses and damages. What is interesting is that when you look at the decision on adopting the Paris Agreement, and when you read para 51 of that decision, it says very clearly that Article 8 shall not be used to claim compensation or liability for loss and damage. So, to my understanding, then Article 8 under the Paris Agreement with respect to loss and damage also does not talk about liability for loss and damage, that who will be responsible for the damage that has been caused. Rather, it says that all states have obligations to prevent and to address the impacts of loss and damage, right? Now, what does the draft resolution do? The draft resolution says very simply, legal consequences for losses and damages for states which, due to their inaction or action, have caused harm to the climate system and other parts of the environment. Now, it doesn't use the term losses and damages, but when you try to understand what the question is saying, for me, it simply says who is liable for the loss and damage that has been caused, and what are the consequences of such liability, right? Particularly in the context of losses and damages or climate harm that has occurred in small island states or other developing countries that are vulnerable to the impacts of climate change. Now, what this does is, this does two things. One, it requires to make a determination that who are the states that are responsible or that are liable for the current losses and damages or the current climate harm that we are seeing. And second, what are the legal consequences for these states? Now, why is this not as straightforward as it seems? While this is definitely, it breaks a new ground because it links liability with loss and damage. It tries to establish liability for loss and damage. Why is this not as straightforward as it seems? Is because first you need to determine which are the states that are responsible for the climate harm that we are seeing today. Now, climate science has progressed enough to perhaps point towards historical emitters and hold them responsible for the global warming or the climate, global warming that we've been witnessing since the 1950s, or the extreme weather events that we are witnessing over the last decade or so, right? But we just spoke, in the last question is about how historical emissions or historical responsibility for disproportionate emissions has always kind of been a sore spot for countries, right? Developed states have never wanted to even accept liable obligations on the basis of historical emission. So what are the chances of them accepting liability on the basis of historical emissions is something that we have to wait and watch. Because historically, there has been a pushback from the developed states in linking liability with loss and damage, or in other words, establishing liability for loss and damage, bringing those two sort of terms together. Which is why perhaps Article 8 of the agreement very clearly only talks about obligations and not liability, right, of the Paris Agreement. And therefore, the draft resolution does break new ground in that sense. But what needs to be seen is then to what extent will this be welcomed when the resolution, it's been tabled now in the General Assembly. So to what extent will this be welcomed? Now, I think I might have mentioned this in the beginning. It's projected that around 100 states have supported the resolution, have supported Vanuatu's and the coalition's draft resolution. But my question would be, what version of the resolution has been supported? Of course, we won't know that until the final voting. I think it's supposed to happen in January. We won't know until then, and the final document that comes out. And I think I remember reading somewhere that some of the historical emitters have also supported the resolution. But hopefully, it will not be a diluted form of the resolution that has been supported. And hopefully, it will be the resolution and the questions as such. Because question 2, like I said, then does reintroduce this element of historical responsibility, and says that states that have so far, due to their action or inaction, caused this damage, what is their responsibility? And that directly relates to historical emitters, right? So in that sense, yes, the resolution is groundbreaking. Definitely, it is much welcome, move. And so far as it's been projected, several historical emitters have also supported the resolution. But I think we can only conclusively comment once the GA has finally voted and we have the final document ready for the advisory opinion, seeking the advisory opinion of the ICJ.
Thank you so much, Kanika. I just had one follow-up. So you said that the liability cannot reasonably flow out of the Paris Agreement because there is no provision for liability.
Yeah.
Do you think there could be any other provision, international agreement, custom or something that could be used to impute liability? Or is it just like a lost cause?
No, so I wouldn't say it's a lost cause, because see, there's definitely liability for transboundary harm, and we have principles for that, right? I think we also have a convention for that. liability for transboundary harm, and climate change is a transboundary harm. And there have been other environmental damages that are transboundary in nature, for which the states have gone to the ICJ and sought compensation for that. But like I said, transboundary harm is a tricky space, because, and climate change is actually a tricky space, because while it is transboundary in nature, this causation link is always a problem, right? Now, of course, science is also catching up, and so we have had, IPCC reports that say that yes, greenhouse gas emissions are the cause for the climate harm that we are witnessing. So yes, I do think that transboundary harm could be one of the grounds for probably moving the court and trying to establish liability. But so far, it hasn't been, to the best of my knowledge. Interstate disputes have talked about transboundary harm, but not climate change as such. So I think in that sense, this resolution and the court's advisory opinion becomes very important. And we'll see how the court addresses this question.
Thank you so much, Kanika, for this insightful session and for coming on here. Do you have any concluding remarks on the general trend of climate litigation or the global South's response to climate change in general?
So I think my general comment would at this point only relate to Vanuatu's, this brilliant document that they have formulated. And like I said in the beginning, all of this discussion aside, but let's remember one thing, that the court is it's completely within the court's competence to give this advisory opinion and for the GA to seek this advisory opinion. And therefore, there shouldn't be pushback from the states. It's a matter of climate injustice. And I remember hearing one of the COP speeches last year where I think the head of one of the states said that it's climate change for those who are not facing its impact. It's climate crisis for those who are. So I think while voting, this should be kept in mind. And what is important is that the language of the resolution is not diluted and it goes as such to the court.
All right, Kanika, thank you so much for coming on here. We're really grateful for your insights.
Thank you so much for having me.